Hi everyone, I'm David Fisher, and this is Presidential Perspectives, where we take a look at current events through the lens of American history as seen through the lives of the presidents of the United States. This episode focuses on nullification. On her first day on the job, President Trump's new Attorney General Pam Bondi placed a hold on federal grants going from the Department of Justice to so-called sanctuary cities. Sanctuary cities had passed local ordinances to effectively say they're not going to implement at least some federal immigration laws, an act that we would historically call nullification. Now, nullification is pretty rare in American history, but not for lack of effort, including a couple of seminal efforts. We're going to talk about three of them in this episode, kind of what happened, why, and the results, because the bottom line is nullification in the United States hasn't gotten very far. So we go back to the beginning, 1798. John Adams is president of the United States. The Americans are in a kind of a quasi-war with France. Many people are asking for a formal declaration of war. Adams isn't ready for that. He's continuing to pursue diplomacy while also focusing on preparedness. But Congress went even further and passed a couple of laws. One was called the Alien Act. The other was called the Sedition Act. And under the Alien Act, the president was given the authority to remove any foreign national, really for any reason, without any due process. Under the Sedition Act, it became illegal to publicly criticize either the president or the federal government. Now, a bunch of people cried foul. This is unconstitutional, a violation of the First Amendment, and the leading objector happened to be the vice president of the United States, Thomas Jefferson, who was John Adams' political and ideological rival. There was no judicial review yet at the time. The case of Marbury v. Madison would come along a few years later, which gave the courts the ability to declare federal laws unconstitutional. So for now, Thomas Jefferson was looking to fill that gap with this notion of nullification. He believed that states could declare federal laws unconstitutional within their state. And he pursued this with a state legislator by the name of John Breckinridge in the state of Kentucky. It was called the Kentucky Resolution that passed under the pen of Thomas Jefferson, who wrote that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. As in all other cases of compact among powers having no common judge, each party has an equal right to judge for itself, as well as of infractions, as of the mode and measure of redress. Now, Jefferson felt so strongly about this principle, that he wrote his friend James Madison that, look, if we can't get our way here on nullification, we should probably just leave the Union. He was advocating potentially for secession in this letter. But determined were we to be disappointed in this, to sever ourselves from that Union we do much value, rather than give up the rights of self-government, which we have reserved and which alone we see liberty, safety, and happiness. Now, the secession part was a bit too far for Madison, but Madison did sign on to this notion of nullification. In his state, Virginia, he issued the Virginia Resolution, which passed and said, in case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and on duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them, to interpose effectively to nullify that federal law. So what happened with all of this? Well, essentially nothing. No other states signed on. Adams avoided war, and the whole thing became moot when Jefferson became president in 1801. But the idea was out there. Even after Marbury versus Madison, the courts took on that role of judicial review. Many still believe that the states had the authority to declare odious federal laws to be unconstitutional and therefore void within their jurisdiction, often pointing to Jefferson and Madison as the precedent. Things heated up again in the 1830s over a tariff that had been passed under President John Quincy Adams in 1828. It was so-called Tariff of Abominations. Abominations to the people in the South. Tariffs very controversial in the 19th century, particularly based on where you lived. The manufacturing centers in the North liked high protective tariffs to keep out foreign goods, but in the South and in the West, where they were more likely to export agricultural products, raw materials, they did not like those high tariffs, and they particularly didn't like this one, which was the highest in the nation's history. The state of South Carolina, leading the opposition against this law, openly beginning to talk about nullification. Now, a new president comes in 1829, that's Andrew Jackson, and he was generally pro-states' rights. but he drew a line, a very firm line, when it came to anything that might impact the Union itself, and that line included nullification and any talk of secession. So things kind of came to an initial head in April the 13th of 1830, ironically at a Jefferson Day dinner being held at the Indian Queen Hotel in Washington, D.C. Customary for the president and the vice president to offer toasts at a Jefferson Day dinner. The vice president at the time was South Carolina's John Calhoun. Again, ironically, you've got one of these rare moments in American history where a vice president and the president very much at odds, because John Calhoun very much in favor of this idea of nullification in his state of South Carolina. Well, to give the toast, Andrew Jackson went first, obviously, as president of the United States, and he put a firm line in the sand when he rose and said, "Our Union, it must be preserved," and everybody in the room knew what that meant when it came to nullification. Well, there was silence, there was tension. John Calhoun, the vice president, then stands up and immediately countered his president with the following toast: "The Union next to our liberty most dear. May we all remember that it can only be preserved by respecting the rights of the states and by distributing equally the benefit and burden of the Union." Again, he wasn't backing down. The lines had been drawn, and things would hardly dissipate over the next couple of years, because by 1832, South Carolina was openly pursuing formal nullification of this tariff. In fact, they passed an ordinance of nullification. This is November the 24th of 1832. Strong references to Jefferson and Madison's Kentucky and Virginia resolutions in their own nullification statement. Forget the courts. This was their responsibility. This law was unconstitutional in their minds. They had every right to nullify it, but not to President Andrew Jackson. Certainly not going to happen on his watch. A forceful denunciation followed in the following month with his own nullification proclamation. According to Jackson, "I consider then the power to annul a law of the United States assumed by one state incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, inconsistent with every principle on which it was founded, and destructive of the great object for which it was formed." He immediately threatened federal troops to come in and enforce that tariff within South Carolina if they didn't withdraw their ordinance. In fact, he sought a so-called force bill from Congress to give him the authority to do that. Civil war very much possible at this point. Fortunately, cooler heads prevailed. Henry Clay and Congress were started to work behind the scenes on a compromise tariff, something that would gradually bring those tariff rates down over the next couple of years. The South eventually came on board. South Carolina withdrew its ordinance of secession as the force bill passed, but never used by Jackson because the issue went away. The scorecard here on nullification so far, 0 for 2. They've tried twice. Federal government stood up to them both times. Now, the true national fracture really started emerging in the 1850s after the Mexican War. All this new land coming into the United States, the issue of slavery expansion on sort of the forefront, very controversial between North and South. Once again, Henry Clay in Congress working on a grand compromise to settle things down. Became known as the Compromise of 1850. Several laws passed, all kind of working together to try to give something to the North, something to the South, and what the South wanted and got was a much more stringent fugitive slave law. Now, the requirement to return runaway slaves is actually in the Constitution, but this law went a little further. It posed penalties, fines, jail time for people in the North if they did not cooperate in returning runaway slaves. Well, Millard Fillmore took over the presidency in July of 1850 after the death of Zachary Taylor. He supported the compromise measures, he signed them in the law, and insisted that they would be enforced to the limit, including the things that the North got as well as the things for the South. Well, people in the North very unhappy with this whole fugitive slave law. It brought the object of slavery very much into their own hometowns, where they were being told you could be fined, you could be jailed if you did not cooperate in returning these runaway slaves. They started passing so-called liberty laws to nullify the fugitive slave law within their communities. Now, Millard Fillmore, as president, a strong, strict constructionist, was simply not going to tolerate this. He was going to enforce the Constitution and the national and the federal laws to the limit. According to President Fillmore, with what face could we require the South to comply with their constitutional obligations while we in the North openly refuse to live up to ours by the nullification of the fugitive slave law? I am committed at all hazards to do my part toward executing this law. I admit no right of nullification north or south. North or South. In fact, he added in a letter to Secretary of State Daniel Webster that God knows that I detest slavery, but it is an existing evil for which we are not responsible, and we must endure it and give it such protection as is guaranteed by the Constitution till we can get rid of it without destroying the last hope of free government in the world. On occasion, he actually sent in federal troops, federal marshals, to try to enforce that fugitive slave law. What did that do? It just made the people in the North that much angrier, pushing the two sides, North and South, even further apart. Now, what happened? Well, kind of less focus on this piece. When the Kansas-Nebraska Act was passed a couple of years later, the fighting kind of shifted to the west. You've got bleeding Kansas. That's really sort of the nexus of this North-South divide throughout the latter part of the 1850s. None of this would be settled, of course, until the North prevailed in the Civil War in the 1860s. The bottom line now on history of nullification, though, attempts have been rare. They've been typically met with very strong resistance from the federal government, typically not successful. There have been some other kinds of nullification attempts as well by states when they've not tried to focus on federal laws, but actually orders of federal courts that they found odious and tried to nullify. We're actually going to talk about those in our next episode. For today, that is nullification, its history here in the United States. For more on this issue, check out some of those videos in the description where we get into more of the details of some of this stuff in the Presidential Chronicles videos. Check out my books on Amazon.com. Don't forget to subscribe to this YouTube channel. And for now, I'm David Fisher. This is Presidential Perspectives from Presidential Chronicles.